No, Your
Okay.
Honor.
With that, then, Ms. Garcia, would you please begin the announcements?
Alexis Garcia for the department.
Richard Saldivar for the mother, Ms. McNeil. Ms. McNeil, will you announce, please?
Hello, I'm Janice McNeil, or Janice Swan, mother.
Deborah Fuller, attorney ad litem for the child.
Sarah Woods, Hill Country Casa, guardian ad litem case supervisor.
Myra Cueva, CPI investigator.
Kristen Evans, CPI supervisor.
Before we begin, I see that Ms. Swan is on a phone that says Debbie McNeil.
That's my aunt, Your Honor.
Okay, is that the Debbie McNeil that knows me?
That is, yes, sir.
Hi, Debbie.
How are you?
I'm well. How are you?
I'm good.
Hello. Before we begin, I want to make sure everybody knows that I do know Miss McNeil. I have worked with her in the past when I was an attorney. I need to know right now if there's going to be any issue, if she's affiliated with this case, if there's going to be any concerns or conflicts before I begin the hearing and engage in this at all.
I don't see any, Judge. Ms. Swan, do you see any conflicts, Ms. Swan?
I don't believe there's anything to be conflicting about, so no.
None from us, Judge.
And Your Honor, for the record, I was involved with the biological mother as a CPS attorney, and I did terminate the biological grandparents' rights to the biological mother many years ago. So I don't think it's a conflict, but I needed everyone to know that.
Okay. Ms. Garcia?
No objection, Your Honor.
Okay. And for the record, if nobody's opposed to Ms. Fuller continue, I don't have an issue with it. My association with Ms. McNeil was professional based on civil issues, completely separate from this. So I don't have any bias. I don't see any problem with me being fair and impartial in this case, but I wanted to make it known on the record that I do know her and I have worked with her in the past. So as long as everybody's okay proceeding, if at any point you're not, you need to let me know. Otherwise, I'm going to go ahead and proceed. I don't feel like it's enough of a reason for me to recuse myself at this point. Okay, then with that, do you all have an agreement?
Yes, Your Honor, there is agreement amongst the parties.
Okay, could you state the terms and conditions for me, please?
Yes, Your Honor. So the agreement is for the department to continue joint managing conservatorship of the child, for services to be assessed at the family group conference. There's also an agreement to have visitation be determined based on therapeutic recommendation between Ms. Swan and the child. And the department will make efforts to accommodate whether there can be family visitation depending on the facility's availability.
Recommendations on visitations depending on facilities availability. Is that what you said?
The visitation for other family members, whether they can accommodate multiple family members. However, we're asking for a therapeutic recommendation for visitation between mom and child in regards to the amount of hours and time and frequency.
I got that. I just didn't hear that last sentence, but I think I understand now. Okay. Any other terms and conditions?
That's it, Your Honor.
Is that your understanding of the agreement, Mr. Saldivar?
Good. I just want to clarify for mom's visitation. She's visiting now. I don't think there was any disagreement on her continuing an open visitation with the child, especially because I think the child wants the visitation now at placement. I think that it was more geared towards if the therapist makes a recommendation that they need to limit some contact based on progress or something like that, then we would be open to discussing that limitation on visitation. But I don't want it to come off as like she's limited now until the therapist says she can visit. That was my understanding of it. So if there's any confusion on that, I think we might have to have brief testimony, but I think that's kind of what I took from it and what Ms. Swan was taking from it as well.
No, that's correct. Mr. Saldivar, that's correct.
Okay, so then just so I understand, visitation is going to continue as normal, but if the therapist has another recommendation, court's going to take up the recommendation.
That's correct.
Okay.
Yes, Judge.
All
there you
right,
go.
Ms. Fuller.
The only other issue, Your Honor, I agree. I have an agreement with all that, but my client has requested that she have contact with her siblings. She hasn't seen them in an extended period of time. And so I am requesting supervised contact with the siblings in a supervised setting.
Any objection?
Yeah, yes, they
Um,
objected.
Yes, Your Honor. The department's objection we would just ask that those visitations would be based off of therapeutic recommendation, meaning those would start when a therapist has signed off on that.
It's same here, Judge. The children haven't seen each other for a while. My client's just concerned that throwing them back into visitation might cause some issues. So we're just looking for a therapeutic recommendation before that starts.
All right, Ms. Fuller, is your request for that solely based on your client's request for it?
Well, I mean, I also feel that sibling contact is important. I mean, it's going to be supervised and it's going to be in a controlled environment. And she feels abandoned to some degree, and she already has a RAD diagnosis. So I think that it's important that she understands that they're, the siblings and people in her family still want to be a part of her life.
Help me understand, Ms. Garcia, the department that belongs trepidation about that contract right now.
Yes, Your Honor. So it's very similar to what Mr. Saldivar said, just in the fact that they have not seen each other in 9 months. There's some behavioral issues when it comes to siblings, and we would just ask that the child be eased into that visitation from not seeing each other for 9 months to having visitation right off the bat. We would just ask that it be eased into. We're not in objection to the visitation as a whole. We would just ask that for therapeutic recommendation before that starts.
The same argument, Mr. Saldivar, or something else?
Same argument, Judge. And I don't know if Ms. Swan wants to just chip in on this since it's a joint case. But I know the other children aren't a part of the suit, but it also affects their environment, their mental status and stuff. So I'd like the court to consider maybe family therapy. If the therapist for the current child in placement says that she's ready to go, then maybe also have a family therapist involved with all the children to see if that's appropriate, and then kind of guide them to start building that relationship again. Because again, it's been 9 months, and I understand that the children want her home, and so if they see her right away, that may cause some issues in the home. So and Judge, I'd like, if Ms. Juan wants to just add on to that to so that you know what the concerns are, I'd like her to address that as well.
Yes, I would like to add on if I could.
Yeah, you can. I just know that I've read the affidavit and I know a lot of what's going on. So you can just hit the highlights for me as to why you think that you need to wait or you need a therapist recommendation.
Basically, the children that she was in the home with are her biological siblings. There has been a lot of mental and physical abuse throughout the years. Since she has been placed outside of the home, it is the only time that they've actually came to me expressing that they feel safe. They have expressed their feelings of loving her and wanting her as a sister, but not wanting her to return home because basically they feel unsafe or they're worried that she's going to harm somebody, or one of the children even said that they're not going to be strong enough to keep her from manipulating or bullying them. Academically, they have just soared and went from the very, very bottom of their class and their grades, barely making it by, to being, A honor roll and skipping grade levels in different areas, not actually bumping grades, but going from, third grade reading level to fourth grade when they were in like a academic probation kind of setting the year before. They do love Mally, but they have also expressed that they're not comfortable with it, and they're scared for seeing her again. But it's not that they don't love her or want to eventually see her. They just, I think they fear that it's going to happen again. Because
Okay.
honestly, with her diagnosis is there's no promise that it won't in the future. And I really don't want it to jeopardize the progress that they have made.
All right. Let me hear from Miss. Is it Miss Perez, or is your last name different? Are you just signed under Perez?
It's Cuevas. It was signed on a different.
Okay,
Cuevas.
All right. Can you tell me what your opinion is based on your knowledge of the case with this contact that's being requested by the ad litem? You were unmuted and now you're muted again.
So when I met with the siblings at the school, I remembered mom did requested for me to not do like a full interview based on their past traumas. She did disclose to me that they love their sister. However, since she's been out of the home due to the last incident between Melissa and Cohen, the sibling, and the police was involved, she pretty much didn't want them to have any type of contact until Melissa was kind of like better. For them to kind of like heal and start that process. She did told me that she was interested in possibly family counseling, but her main needs were kind of like trying to see where Melissa can find the help that she needed.
Okay. Thank you, Ms. Cuerpos. What's CASA's take on this?
CASA is aligned with the department right now. Normally, I am all about sibling visits, but I think there's some safety concerns right now. And I do agree with Ms. McNeil that we do need to ease everybody into this. 9 months is a long time not to see your siblings. And I think going straight into that would be a culture shock for everybody.
Okay. Ms. Fuller, any rebuttal to any of that?
I mean, I just feel it's important. When I spoke with her, that was her biggest concern. She told me on Sunday that she hasn't had any contact with anybody, with her mothers, with her siblings, since she's been there. And so that concerns me. And I really feel like she needs to, I mean, she feels abandoned. And I think she needs to get services, but I think it's important to know that she's able to see her family. She hasn't been able to.
I can certainly understand that. I think I want to hear I'm looking at the pleadings right now.
Your Honor, I do want to say that I have had contact with her since she's been in placement at this RTC, and I was in contact with her when she was in the behavioral health hospital and did plenty of visits there. I was not able to contact her till I was given the appropriate contact information at her current placement. But since I got that contact, I have been talking to her every night.
Okay. Thank you, Ms. Wynn. Is there anything else outside of that you wanted to report to the court, Ms. Fuller?
I mean, Ms. Juan suggested looking into Meadowlands because Melissa had went to school, the charter school there. So I mean, I would ask that Belong look into that placement. She's in a facility that's only been open 2 months, and it has been a little difficult to get information from them. So if she's already used to the charter school at Meadowlands, and if they have an opening, and if she qualifies to be there, I would ask that Belong look into that.
Okay, thank you. And Ms. Cuerpos, you did discuss prior to the department filing suit the idea of the option of the joint managing conservatorship with Ms. Juan.
Yes, we did. And also the staffing supervisor, the covering supervisor had a conversation with mom as well.
Okay. You believe that this order would be necessary, considering the circumstances, that there's no other way we can do this?
Yes, I believe so.
Okay. Anything else that you're requesting today, Ms. Garcia?
No, Your Honor, nothing further.
All right. Ms. Cuerpas, do you believe that the department made all necessary reasonable efforts to avoid a removal?
Yes, I do.
And do you believe that the reasonable efforts that were made were consistent with the circumstances and provided for the safety of the child to eliminate or prevent the need for the removal?
Yes, I do.
Do you believe that the department has made all reasonable efforts to allow the child to return home, but there's a continuing danger or substantial risk of continuing danger if the child is returned home?
Yes.
All right. And you believe there was a danger to the physical health or safety of the child?
Yes, I do, which it was her own mental health.
All right. Anything else from CASA?
No, sir. We would like for sibling visits to start at therapeutic recommendation. And Ms. Wan did mention, which I think is a good idea, that Melissa have the opportunity to be a pen pal with one of her friends from school. I think that'd be a great option for her to have some community.
Okay.
With the recommendation from the therapist, is the well-being and the well-being of the other children going to be considered?
Well, and that's obviously what we would be looking at, Ms. Wong. I want to make sure something's very clear to you as we move through this case. So this is a joint managing conservatorship case. That's what the order is going to be, but it's still a child welfare case. It's still a case that has been initiated by the Department of Family Protective Services. We're having a hearing. So I'm going to make some orders that in some ways are going to sound somewhat adversarial, but I just need you to understand that's the only way we can do what it is that needs to be done. But the understanding is that you and the department and then the other professionals involved, the goal is to get Melissa the help that she needs. Okay. And to do that in a way to where we have the resources available to us through this system. It is going to require some work on your part as well. And what's going to happen after this hearing, after I make my ruling, is there's going to be what we call a family group conference. And at that family group conference, the services that are set forth are going to be predominantly in the best interest of getting Melissa the help that she needs. But there are also going to be some services and things that you're going to be required to do. We have a year to do that. And that year started March 21st, 2025. And that year is going to end March 23rd, 2026. Hopefully it won't take that long, but you'll have to be patient and work with the department through this process, just like everybody else is going to have to work through the process too. What I can tell you what I've encountered both as an attorney in these cases and also as a judge presiding over them is sometimes it seems to the parent that things aren't being done the way they want them to be done. I need you to understand that you've got to communicate with your caseworker, you've got to communicate with your attorney, with CASA, and Belong, who's going to be doing the conservatorship part of this, to make sure that you're working just as hard as they need you to work, so that whatever services Melissa is receiving, you're receiving the services that you can use to help you do things appropriately for her. Maybe tools that you didn't know of beforehand. So I'm going to make a ruling here in a minute that's going to sound like I'm ordering you to do things, which I am, but it's in a joint managing conservatorship effort to do what's best for this child. I say all of that to make sure you understand the overriding interest in this case is what's in Melissa's best interest. So there may be times where orders may be made that don't necessarily take into account the best interests of your other children in the home. That's not to be difficult, and that's not to make it sound like they're not important. It's just that the child before this court is Melissa. And so the orders I'm going to be making are in Melissa's best interest. Does that make sense?
Yes, Your Honor.
Okay. Now, I in no way, shape, or form want to do anything that's going to harm any children of the family who are not before this court. So I need that information, but I just need you to understand that's the rubric I have to operate under. Okay?
Thank
So you're welcome. All right. So for the purposes of the adversary hearing, the court will find that the mother, Ms. Juan, was served on March the 24th, 2025 by personal service. She's appeared here with her attorney. Ms. Juan, are you able to afford an attorney to represent you in this suit?
No, Your Honor.
Do you have anything you could sell or any assets you could liquidate that would allow you to pay for an attorney?
Maybe like old play equipment, but that would be about it.
Okay. So are you receiving any type of governmental assistance at this time?
No, Your Honor.
Okay. Is it your testimony to the court that you cannot afford an attorney to represent you in this case?
Yes, Your Honor.
All right. I'm going to find that Ms. Juan is indigent for the purposes of this case. I'm going to continue to have Mr. Saldivar represent her. Ms. Cuerpas, is there any Indian child heritage in this case that you're aware of?
No.
Okay. Court will find there's no Indian child heritage in this case. Court finds that the parties have entered into an agreement for the Department of Family Protective Services and Ms. Juan to be joint managing conservators of the child, Melissa. Court finds that's in the best interest of the child. Court finds that the agreement includes that the parties will hold a family group conference and determine which services are necessary to proceed in this matter. Court finds that the parties have entered into agreement for visitation to be determined based on therapeutic recommendation between the mother and the child. I want to make sure that the order states that the visitation that's occurring right now shall continue subject to any therapist recommendations. So I'm not changing what's happening right now. I'm just making sure everybody's on the same page that it could change based on therapist recommendation. The recommendations will also be made as far as visitations of other family members, and that will be based on the ability of the facility to accommodate those visitations. Court understands, and I'm making orders based on those findings as stated. Court understands that the child, Melissa, would like to have visitation with her siblings. This time, based on the testimony provided in the best interest of the child, I'm going to order that those visitations be based on therapeutic recommendation as well. So we're not going to have any visitations between the siblings occur until a therapist has weighed in on what would be appropriate. I'm also going to order that Melissa be allowed to have a pen pal option as stated by Ms. Woods. I do want her to have some contact. I don't want her to feel completely alienated. We'll have our status hearing May 14th, 2025 at 9:30. May 14th, 2025 at 9:30. For the purposes of the requested relief, I do have to make the findings that there was a danger to the physical health or safety of the child caused by an act or failure to act of the person entitled to possession, and for the child to remain in the home is contrary to the welfare of the child. The urgent need for protection required the immediate removal of the child, and reasonable efforts consistent with the circumstances and providing for the safety of the child were made to eliminate or prevent the child's removal, and reasonable efforts have been made to enable the child to return home, but there is a substantial risk of a continuing danger if the child is returned home. Again, I understand this is a joint managing conservatorship case. There's a reason I'm making those findings in this case, and it has a lot to do with funding. All right. We're gonna come back, like I said, ma'am, on May the 14th at 9:30 for a status hearing. And at that status hearing, I'm gonna hear how the child is doing, how you're doing, and what services were ordered at the family group conference. And I'm gonna decide which ones to make orders of the court. I have to admonish you, and I already kind of told you, we get a year for you to demonstrate that you can provide the child with a safe, stable, violence and drug-free home. Obviously, we're not looking at this like we are at some of the other cases. This is joint managing, and you're just working along as well as she is. But I just want to hammer home that point that there is a time limit on this, and we have to get everything figured out within that time limit. Okay. Hopefully, we can get it done a lot faster than the time allotted, but that remains to be seen. A lot of that depends on Melissa's progress. Miss Garcia, anything I failed to address at this time?
No, Your Honor, there's nothing further. Thank you.
Your
Okay.
Honor, I had another issue. I noticed that the child caregiver resource form was left completely blank. I would ask that it be filled out. And I wrote this down, and maybe Miss Juan can help me. I'm not exactly sure what it was. A Bitsy video game that she wanted. If that makes sense.
Sorry, it's a little toy.
Okay. That was the only other thing that I couldn't read my writing. So
I've had that problem. Okay. I'll order that Miss Juan fill out the child caregiver resources form. That could come in handy. And then also order that the child get the Bitsy video game. If that's something that's going to make her feel more comfortable, we need to do it. Subject to whatever the facility thinks is appropriate, obviously. Okay. Well, thank you all for your time and your service. I'll see you May 14th at 9:30. Nothing further. All parties are excused. Thank you. Good to see you again, Ms. McNeil.
thank you, Your Honor.
You're welcome. Thank you.
Yes, Judge Drake McCusker, attorney for the department. Ms. Sherrod Buckner.
Pearlie Sherrod Buckner, permanency specialist for the case.
Christy Knopp, permanency supervisor with Belong.
Richard Saldivar, attorney for the mother, Ms. Juan. We're ready, Judge.
Janice Juan, mother.
Deborah Fuller, attorney ad litem for the child. Your Honor, ready?
Sarah Woods, Hill Country Casa, guardian ad litem case supervisor.
Kim Richardson, Hill Country Casa, guardian ad litem for the child.
We are here for a status hearing, and Ms. Sherrod Buckner, your report states that at this time Melissa is 10 and she's in an RTC in Travis County. Is that still correct?
Yes, sir, that is correct.
Is that placement meeting her needs, and is it safe and appropriate?
At this current time, yes, sir.
Is it in her best interest to remain in that placement?
At this current time, yes, sir.
Okay. Do you believe that there's probably something better we could be doing for her?
As it relates to her placement or overall?
Placement.
Yes, sir.
All right. Tell me what you're thinking and what you're concerned about with this placement.
Yes, sir. I know I am very new to the case, so currently right now we have been working with placement, ensuring that they are staying on top of her medical, her dental, and also her therapy. She is also receiving skills. I know in the beginning there was some delays with trying to get that started. At this current time, everybody has been in agreement to have her move closer to a different RTC. Right now, we are pending a psychological because that current RTC does want an IQ. So right now, we're just trying to get some paperwork together and complete the psychological so we can have her move to a different RTC.
Okay. So there's not something that's imminent or some danger or emergency concern. It's just a matter of time before we can get her moved to someplace that everybody agrees is more appropriate.
That is correct. So nothing
Okay.
imminent that needs to be addressed right now. No, sir.
Okay. All right. She's up to date on all of her checkups.
Yes, sir, she is.
And She is receiving psychotropics and therapy, or she's pending for therapy?
She has had her first therapy appointment, and she's also meeting a psychiatrist that is also monitoring her psychotropic medications.
Okay, and those reviews are up to date?
Yes, sir.
How are her behaviors right now?
Right now, according to the current placement, there is no concerns. She has been going to school, has not been refusing anything like that. I did meet with her, to believe, the last week on Tuesday. No concerns at this current time regarding her behavior.
Okay. And then the parties were able to hold a family group conference.
That is
Excuse me. Yes, a family group conference.
Yes, sir.
And were you able to develop family plans of service that were narrowly tailored to address the concerns that brought Melissa into care?
Yes, sir.
And Miss Swan was able to participate,
Yes, sir.
and she participated in the creation of her plan.
Yes, sir.
And did she review and sign that plan?
She did review it. She did receive a copy, but she did not sign.
Okay. Is there a reason she didn't sign, just because it didn't happen, or because she didn't want to sign it?
It was some things that her and her attorney wanted to discuss regarding some of the services we were requiring Ms. Warren to complete.
Okay. But she does have a copy of it,
Yes.
and it has been filed with the court.
Yes, sir.
All right. You believe this family plan of service is not only narrowly tailored, but it's also in the best interest of the child?
Yes, sir.
Okay. How is visitation working out at this time?
At this current time, mom does get phone calls. That is through current placement. She is supposed to call between, I do believe, 3:30 and 4 o'clock. There is no time limit on how long she is on the phone. When I did speak to Miss One, I think the last phone call was maybe 30 minutes or so. I think it's just more so how long that Melissa can kind of like tolerate being on the phone. Mom does get in-person visits as well. Her next visit will be, I do believe, May 17th from 11:30 to 2. Me and Miss One did discuss for the next visit, she will go through placement to ensure that those visits are happening.
Okay. Now, if we've just now started therapy, that means that we don't have any kind of recommendation for the therapist on whether or not sibling visits are appropriate, correct?
That is correct.
So it's still not happening.
When I spoke to Miss One, I don't think it is at this current time. I did ask Miss One if she was also getting phone calls at the same time. Just kind of say hi. Miss One did say no.
I do want to say that the arrangement was for
Your Honor, I'd object to her
Hang on.
testifying.
Hang on, Miss One. You can't testify unless somebody's asking you questions, okay? All right, so those aren't supposed to start until there's a therapist recommending that it starts, correct, Miss Sherrod-Buckner?
According to my understanding, yes, sir.
Did she get her video game?
Not that I'm aware of, but I can check on that.
Well, it was an order as of April the 2nd. I ordered that. And did mom fill out the child caregiver resources form?
Yes, sir. I do have that.
Okay. And then what about the pen pal option for Melissa?
I'm not aware of that either, but I can look into that. Yes, sir.
Okay. I ordered back on April 2nd that she have the pen pal option because that was a discussion during our adversary. And I also ordered that she get I think it was called a Bitsy video game. She was requesting it. I ordered that be made available to her. So we need to check on those two things. Is Miss One cooperating with you?
Yes, sir.
And at this time, are you asking for any changes to the current orders?
Not at this current time.
Okay. Is it safe to return the child to Miss One today?
Not at this current time.
Are there still concerns that she has not yet addressed and the child has not yet addressed?
That is correct.
And so is it in the best interest of the parties, child and the mom, for this case to continue and for Melissa to remain in the temporary managing conservatorship and belong in the department.
Yes, sir.
Mr. McKeska, do you have questions for Ms. Sherrod Buckner?
Just briefly, Judge. Mr. Buckner, I think you testified to it. I just missed it. But what is the current visitation plan or schedule? Is there one in place, or is it just kind of open to whatever the child and mom are available?
At this current time, Ms. One will get weekly phone calls. And those phone calls, I do believe, either Thursday or Friday, between the hours 3:30 and 4 o'clock. And then right now, far as in-person visits, it would be more so when Ms. One can be available due to the distance.
Okay. And are those phone calls supervised?
No, sir.
Okay. And the in-person visitation, is there any requirement for that to be supervised either?
No, sir.
Okay. Pass the witness, Judge.
Mr. Salomar?
Yes, Ms. Buckner, the psychological you mentioned for Melissa, has that been scheduled yet?
No, sir, not at this current time. She needed to see a psychiatrist, and then the next step for that would have been scheduled for psychological.
Okay, has she seen a psychiatrist?
Yes, sir.
Okay, and when did she see the psychiatrist?
May 8th.
Okay, and so when do you anticipate the psychological getting set up?
It will be according to placement, since they will have to be the one that has scheduled it. But I've also sent a referral to our provider that we use. He is also able to complete a psychological. So we're just waiting on an open slot. So I have completed one referral for our provider and then the provider for the RTC.
Would an order from the court to get it expedited or as soon as possible, would that assist this process?
No.
Okay. And that's the only thing that's holding up the potential placement that's closer to mom?
Yes, sir.
Okay. Now, what services exactly are you asking for Ms. One to complete?
Yes, sir. So I am asking her to complete a parenting course, followed by individual counseling, and then also a psychological.
Has she started the individual therapy?
Yes, sir. She has had her intake.
Okay. Has she maintained contact with you?
Yes, sir. She has.
Has she expressed any concerns about the current placement to you?
Not recently. No, sir.
Okay. What were the concerns that she's expressed to you in the past?
Her concern was that that she was not given her medication, far as like her medication being picked up. There was a concern regarding medication that had been at the pharmacy that was not picked up, and Ms. One was getting phone calls that those refills was ready. I do believe Ms. One has also made concerns regarding her child being at placement. There was a incident that had happened where she had ran away from her current placement, but placement was able to speak with her, as far as like Melissa, to bring her back to the home. So it's just mainly their ability to ensure that she's safe.
Have you been getting incident reports from the placement of when she runs away or anything like that?
I've only just, not recently, but I've only just received those previous incidents. Yes, they do send them to me.
Okay, have you addressed that with the placement that the team needs to be informed as soon as possible of these issues?
Yes, sir. When we had our staffing with the placement, they have been made aware.
And also too, was Miss Wan's medication concerns addressed with the placement?
Yes.
Any other issues or concerns with Miss Wan right now?
No, sir.
What's the name of the psychiatrist Melissa's thing?
She is also being seen. It's called Village Center in Austin.
Is that information that you can forward to Miss Wan today so that she can get in contact with them and ask any questions that she may have?
Yes, I can do that.
Okay. Is she seeing any other doctors other than the psychiatrist in that medical group?
Not at this current time, no.
Okay. When was her last medication review?
That was May 8th.
Pass the witness, Judge.
Fuller?
Mr. Buckner, in regards to Melissa, you mentioned that the visitation is whenever it's set up. How many visits has mom had with the child?
I do believe from what I have, if I'm not mistaken, the 17th, I could be wrong, would be her first visit.
She hasn't had a visit yet?
Not that I'm aware of.
Okay. And was there anything that prevented her, did belong prevent her in any way from having a visit?
No, sir. No, ma'am.
Okay. And other individuals have been approved to visit, correct?
Yes.
And who are they? Who are they?
April Punos and Emily Polunos.
Okay. And you've done all the background checks and everything on them?
Yes.
And have they visited already?
Yes, ma'am.
Has anybody else been approved to visit?
Besides myself and the attorney, no, ma'am. I'm the only ones that I do have.
Okay. Have you been asked to look into the backgrounds of anybody else?
No, ma'am.
Okay. In regards to the family plan of service, is Miss Wan married?
Yes, ma'am.
Are you going to develop a family plan of service for her wife?
That was discussed, but I have not developed one for her wife. To my knowledge, Miss Wan's wife did not want to be involved.
Okay, so she's not going to visit. She's not going to see the child.
No, ma'am.
Okay. When you talked about the services, what kind of parenting class are you actually looking at?
Yes, ma'am. So with our essay for fatherhood, they do have parenting course that also tailors to like healing wounded families. So in that, they do get a different variety of information when it comes to bonding with your children, learning how to communicate with your children. That is more focused in those parenting classes.
Okay. And who is the individual counselor that mom is seeing?
Her name is Patricia Boone.
Okay. So, and that just started?
Yes, ma'am. She did have, yes, ma'am.
And why did you feel that the psychological evaluation was necessary?
At this current time with our psychological, it gives us a overall view of mom's understanding of behaviors. It also gives us an overall view of her well-being as well. It also pulls on strength perspectives and also weaknesses. And then it also gives us recommendations at the end on what could be appropriate for mom.
And did you ask that for the mother to also sign a release of information?
Yes.
Okay. How difficult is it going to be to reunite this child in a family when the other parent is not willing to participate in any services or even see the child?
Objection, speculation, Judge.
With her knowledge as a worker, Your Honor, and this is the beginning of the case, and we're being told that there's going to be no participation. I think it's important to have that on the record.
Just rephrase your question.
Thanks.
Ms. Gerard Buckner, when you work with families, do you typically work with both parents?
Yes, I do.
And when you return a child to a home, you would want it to be in a home where both parents want to be a part of that child's life.
That is correct.
Okay. And if you have been informed that the other parent does not want to be involved at all, do you have concerns about that?
Yes.
Okay. And what are those concerns?
Due to that parent also being like a secondary caregiver, my main concern is their ability to understand exactly the content of what they're dealing with when it comes to the child. And then their ability to understand what it would take to parent that child, rather if it's learning coping skills and learning how to maintain their anger when they get upset, learning how to deal with their children's mental health as well as it relates to depression, anxiety.
Okay. And do you feel that all the services that you're requesting will be important if this child is to be reunified?
Yes.
Okay. And again, there was a number of, excuse me, difficulties in the beginning with this placement. Do you feel that they are better understanding their requirements at this time?
I do believe so, now that they do have a person that's working with them as well, to kind of help them to get everything together. Yes.
Okay. Do you have any, in regards to the medication, there was a concern, but they actually had the medication. It was just that the pharmacy was notifying the mother.
That is correct.
But they already had the medication. So it wasn't like she went without.
Correct.
Okay.
According to placement, yes, ma'am.
Just wanted to make sure. And have you discussed with them how it's been difficult for the mother and for other parties to get a hold of them?
Placement? Yes, ma'am.
Yes. And have they worked a little bit harder to get that taken care of?
Yes.
Okay. And what have you spoken to Meadowlands recently in regards to whether once her psychological is done with an IQ that she can be placed there?
We did discuss it there. We have to go through our placement team. We cannot talk to them directly. Their biggest thing is that they're not able to hold a bed, but as soon as we can kind of get the psychological to them, then they would try to finish through the process of getting her moved to Meadowlands.
Okay, but your placement team is working with that.
Yes, ma'am.
All right, I'll pass the witness.
Any follow-up, Mr. McKeska?
No, Your Honor.
Anything else, Mr. Saldivar?
Not for this witness, Judge.
All right, any other witnesses, Mr. McKeska?
Not from the department, Judge.
Mr. Saldivar, you have a witness?
Judge, if time permits, I can call Ms. Juan. We're just basically going to touch on the issues we're having with placement, and I can address the court as far as the visit, the services, and I just have a request for FGCs, Judge, whichever way you want to do it.
If you're fine just addressing the court, that's fine with me. If you feel like you need to get something on the record from your client, we just need to be quick with it. I have a meeting with a child after this hearing that I need to try to stay on schedule for, so I'll let you make that call.
I need to address it on the record, Judge. I think because it'd probably open up a can of worms, so I'd rather address it with the court, and then we can just get some issues resolved in another FGC with my request. Do you want me to do that now, Judge?
Yeah, put on the record and let's get addressed what you think we need to talk about today. We still got a few minutes.
Okay. Well, then I'd like to call Ms. Juan, Judge.
All right, Ms. Juan, you've been sworn, so I need you to unmute, please. And Mr. Saldivar is going to ask you some questions. I need you to please only answer the questions that he asks you. So if he asks you a question that's yes or no, just say yes or no. If he asks you an open-ended question, I need you to keep your answer brief and concise, only to what it is he wants to know. Don't give it any other information. And when he's done, all the other attorneys are going to have the opportunity to ask you questions too. If you hear someone say objection, I need you to stop talking until I rule on the objection, okay?
Yes, Your Honor.
Thank you, ma'am. All right, Mr. Saldivar, you may proceed.
Yes, Ms. Juan, can you briefly tell the court what kind of issues you're having with the current placement as far as visitation is concerned?
She's been there since March 24th, and I've only received 6 calls from the placement as scheduled, and I have made multiple attempts throughout the weeks that she's been there to get a hold of her. I've had 1 visit with her and had 2, I think, rescheduled.
Okay, and when they were rescheduled, is that from you or from the placement?
Between Pearlie and myself.
Okay, and did you have early, when she was placed there, did you have concerns that she was leaving campus and the placement didn't know where she was?
Yes, she had 2 runaway attempts in the beginning, a few weeks. Well, yeah, beginning, I guess.
Okay, and how did you find out about those runaway attempts?
I believe a caseworker asked me one time, and then my daughter told me about the second.
Okay. Did at any point the placement contact you or the department to your knowledge?
Not about the runaways.
Okay. And as far as the medication issue that we discussed earlier, was the placement contacting you regarding her medication?
Yes, placement contacted me asking me for refills. I let them know I had already notified them of them being ready at the doctor's office. And the second time they contacted me wanting to know what medication she was on and if I could get the refills for them. At that time, they had the wrong dosage and I had to reiterate what dosage she was on.
Okay, so just to clarify, because earlier the testimony was that the pharmacy was calling you about refills. Was it also the placement that was confused about her medication?
Yes, so the pharmacy notifies me through the app we have that the refills are ready, and I contacted placement letting them know. And then the placement had also contacted me asking me if they could still get those refills. The previous ones had already been sent back to stock, so I reissued them to be filled again. I'm not sure if they picked them up or not. I do know they took her to the ER to get medication refills at some point in time.
Okay, and they also were asking you what, where, and when she was supposed to be taking, correct?
Correct.
Okay. As far as the services, are you willing to comply with the services the department's requesting?
Yes, I am.
Okay. And we discussed these services, and you specifically want them to address why we're here, correct?
Correct.
Did you have any issue when you did your initial intake with your therapy with Ms. Boone?
It was more of like I'm an offending parent of some sort and not really tailored to what this case is about or the services I'm needing.
Okay. And was that the hesitation to sign the plan that you wanted to make sure that the services are tailored for reunification with your child?
Yes.
And briefly, can you tell me why your wife does not want to participate, if you know?
I'm not sure that she had said that. I know that she usually takes care of the children when I'm dealing with these things. And my daughter had not really wanted a relationship with her after she started having more of the behavior issues. So I kind of took over making sure everything was getting done for her while my wife, usually takes the kids away from the house when my daughter is having times of escalation or any behavioral needs. I know in the beginning it also was a lot to do with her job because she was part of the San Antonio Fire Department, and any kind of threats or things like that, which is what my daughter does, would affect, I guess, the job as well.
Okay. Do you think that she would participate in a family group conference with the parties to discuss her involvement?
I can definitely ask her.
Okay. Now, the only other concern that you had was that some letters went out to recently for family requesting placement of Melissa. Can you tell the judge briefly what the concerns about those letters are?
So I adopted the kids out of CPS, and I want to make sure their safety is, my number one priority. And I'm concerned it was sent out to family members that we have had to cut ties with for their safety. I know the letters that were received were from my current wife's ex-husband of 20 years, extended family. So it wasn't even anybody in our family group or anybody that we've had contact with ever that are reaching out to us wanting to know what is going on.
Okay. Are you also wanting to have another family group conference to also discuss the issue with your wife, but also to discuss which family are appropriate and which you have concerns with?
Yes.
Pass the witness, Judge.
Mr. McCaskill,
No questions.
Ms. Fuller, Ms. Fuller, you're muted.
Sorry, I don't have any questions, Your Honor, just a statement.
Okay, let me go ahead and hear your statement.
I was very concerned about the placement as well. I've advocated for her to be moved from the very beginning to Meadowlands. I don't know why it took so long for them to do what they needed to do in regards to therapy, psychological evaluations. It seems like they have a better understanding now. Unfortunately, they were only open 2 months before Melissa was placed there, so they're a new facility, but it's no excuse. I don't feel like they were meeting her needs at that time. The runaway, she got out of the car and went down the street. They could see her. They did not go after her. It's a one runaway that I was told about. I wasn't told about another one, but she got out of a car because one of the other children in the home was hurting, she said hurting her. So she got out of the car and walked back to the home. I still don't feel like they're meeting her needs, though. I feel like her educational needs weren't met. She has services she should have received. She did not receive for the STAR test. And so I am concerned about the placement. But I am more concerned, though, about this is a JMC case, Your Honor, and we would need participation of both parents. And so I agree with Mr. Saldivar. We need to have another family group conference. I was not even made aware of this. I had to ask the questions about if she was married, what was going on there. And it bothers me today that her wife doesn't want to be a part of this, or, maybe she does, maybe she doesn't. But this child would not be able to go home unless, the family unit is intact. And so I think we need to have another staffing about that. And we need to develop a plan for her wife, because this is a JMC case, and I'm kind of disappointed now that it's a JMC case, because I don't see that the progress can be made without total participation. But I want Melissa moved as soon as possible. I'm hoping it'll be Meadowlands, but again, there's no guarantee.
Okay, thank you. Ms. Richardson, I reviewed the CASA report and I'm aware of the concerns, and I'm going to address the concerns. Is there anything else that you want to report today?
No, sir. I'm testifying on behalf of
Okay.
CASA. Ms. Richardson just signed on to the case very recently.
Okay.
The only thing I would ask for is that Melissa start with ABA therapy and the other services recommended in her psychological, EMDR, neurofeedback, and social skills training.
Okay, thank you, Ms. Richardson.
Thank you.
Yeah, excuse me, Ms. Woods. Okay, then what I'm going to do here
Judge,
is
I'm sorry,
address.
Can I
Yes,
make one request before you do that, Judge?
Just 1 second, Mr. Saldivar, hang on.
Okay, okay.
I'm going to address the CASA concerns, Ms. Woods and Ms. Richardson, in my order, because there's more information I think that needs to be exchanged between the parties. So rather than try to address it all today in limited time, we're going to have another FGC and we're going to go over those issues and some others, but I am going to make some orders. Yes, Mr. Saldivar.
Judge, my client's willing to do the services, Judge. I think the only hesitation was, the first session at therapy was mainly how did you abuse your children? Do you do drugs and alcohol? Kind of treating her as an offending parent. This is a JMC case. We're asking for the services to be tailored more towards joint managing conservator, and that mom is trying to get her child back and ask for help from the department to do that. And so not to be treated as a typical TMC case. So if the department, and I did have a conversation with Mr. McKeska, he said he was going to talk to the department. That's all we're asking, is that the services be geared towards that instead of treating her as an offending parent, Judge.
All right, thank you. Well, before I make any rulings, and again, I've got a meeting with a child client, so I've got to be brief. On this issue of this being a JMC case, that is a double-edged sword, because since it is a JMC case, yes, there's supposed to be a joint effort that's cooperative and communicative to handle the issues pertaining to the child, because the viewpoint of the parties and of the court back on April the 2nd is that the child needs services and the parent is reaching out to the department and belong for help with those services. And that's the understanding everybody has had for a month and a few weeks. So yes, there needs to be an effort to make sure that we're not looking at this like a typical removal. The other side of the blade is that if it's a JMC case, Ms. Fuller is absolutely right. If there's a marriage and we're talking about issues related to the child, and we've only got one spouse involved in the JMC case, then we're only doing half the work that needs to be done. So you can't have it to where you're getting help, but you're getting help on the terms that you want. The help has to be on the terms that are best for the child. And so it's a difficult situation, Ms. Wan, but we run into it a lot when we have dating relationships. We have marriages where the child is not the child of one of the parents. it's got to be both. It's got to be everybody. It's all hands on deck. And if your wife has a problem getting involved in it, then that's going to be a problem. There's no way around that. So that's just the reality of the situation, because what we don't know, and I don't know, and the parties don't know, is where are these problems stemming from? And that's why there's a psychiatric requested and ABA therapy and some of these other things to figure out what's causing the problem to begin with. And we can't ascertain that and get into it unless everybody that's in that household is involved in this case. So I just want to make sure that everybody understands that before I render my order. Miss Sherrod Buckner, there's one question nobody asked you. Is there any Indian child heritage in this case?
No, sir.
Okay. Court will find that for the purposes of the status hearing, there's no Indian child heritage. The placement is safe, but court's going to find that at this time it's not appropriate and it's not meeting her needs. And I'm going to order that the placement be changed as soon as practical. I'm going to order this, find that it's not in her best interest to maintain that placement because it's not doing what it needs to be doing for her. I understand it may be new, but I'm not going to make Melissa suffer for the fact that they're still trying to work out the kinks. Court finds that her medical, dental, and vision is up to date. Therapy has just started. Court finds she is receiving psychotropic medications and those reviews are up to date. Court finds that the visitation schedule with the calls is appropriate at this time. Court's going to maintain the order that there be no sibling visits until we have a recommendation from the therapist. Court is going to authorize the parties to help Ms. Wan with non-supervised in-person visitation as soon as practical. Court finds that her educational needs are not being met at this time based on the testimony and the report that I read that's been filed with the court. I'll take judicial notice of that, and then Ms. Fuller's concerns. So I'm ordering that placement again to be changed as soon as possible. Court finds that the parties held a family group conference and developed a family plan of service for Ms. Wan that was narrowly tailored to address the concerns that brought Melissa into care. And it's in the best interest of the child for that family plan of service to be made an order of the court. Court finds that the mother has reviewed it. She has a copy, but it has not yet been signed. I understand why. And the court finds that it has been filed with the court. We'll take judicial notice of it. I'm going to order that the parties have another family group conference to address the issue of placement, the concerns in the CASA report, in their recommendations. All of that stuff needs to be addressed. And then the issues with Ms. Wan's wife and her involvement in the case. I don't want to put anybody's job in jeopardy, and I don't think it would be putting it in jeopardy for her just to participate in a service plan. But I certainly respect the fact that this is not her child, and I respect the fact that she's not under a legal obligation to participate, but she is in the household, correct, Ms. Wan?
Correct, Your Honor.
All right, and she's going to be in the household whenever Melissa comes back, correct?
Correct, Your Honor.
Okay, so I do have the authority to order that anybody that's going to be in that household participate in services. So I'm going to order that she participate in the services as long as she's a member of the household. I'm going to also order that the parties respect her schedule and respect the fact that this needs to be handled discreetly and it's not everybody's business what's going on, and we need to be careful who we're contacting. I'm going to find that it's not yet safe to return the child home, both for reasons related to Melissa and the home. There's still concerns that exist, and she needs to remain in the temporary managing conservatorship or belong in the department. Our next hearing will be our initial permanency hearing, August 13th, 2025 at 11. August 13th, 2025 at 11. I don't want you to get discouraged, Ms. Wan. This happens in a lot of cases. We get involved, especially JMC cases, because it is a different animal. You know, it's not where the department has full control based on court authority to make you do certain things. It's supposed to be a team effort. And so I think what happened back in April is that everybody was hoping for the best as far as her placement and things of that nature and how things were going to work out. And now we're getting a little further down the road. And I've been in cases like this before, both as an attorney and as a judge, where we just have to tighten up the boundaries a little bit as far as who has what duty and who has what obligation to this and that, and who has what rights. So you're both joint managing conservators of Melissa. You both have the decision-making ability in this case. You both can agree to or argue with things. But at the end of the day, it's all about her best interest, and I'm the one making the orders. And so that's why I'm making the orders I'm making today. I want her out of that placement, and I want visitation to begin between her and her mother. And I want to know that, what's your wife's name? We keep calling her your wife. Just give me her first name.
It's Melissa.
Okay, it's also Melissa. All right. So you and Melissa need to be.
She goes by Mel.
Mel. Okay. You and Mel need to be able to go through this case. But Melissa, your daughter, Melissa, needs to be able to rely on the fact that you're both going to be on the same page when she comes home, because she's going to be learning a lot of things and doing a lot of things throughout the life of this case. And when she comes home, you both need to be aware of what she's done and what she learned. Otherwise, some old problems that may have existed are going to resurface really fast, and then she might relapse on her behaviors that got her into this case. That's why it's important to have everybody involved. Mr. McKeska, let me give the admonishment first. I have to admonish you that the state of Texas gives parents in child protection cases 12 months to demonstrate that you can provide a safe, stable, violence, and drug-free home for your child. In the event you cannot do so, your rights to your child are subject to restriction and or termination. This is a JMC case. The dynamic is a little bit different, but we're still on a timeline. Mr. McKeska, is there anything I failed to address?
Pretrial scheduling order and discovery control plan, Judge.
Thank you. A pretrial scheduling order, which sets out the dates and times of our future hearings, and the discovery control plan, which has the rules for discovery and the timelines on those, will be distributed by the court. Please make sure you sign those as appropriate and review them with your clients. All right. Good luck to you, Ms. Wan. Thank you all for your time and your service. If nothing further, have that FGC within 10 days. That needs to be done in 10 days. Thank you all for your time and your service. If nothing further, all parties are excused. Ms. Fuller, I'm going to leave this open so we can have your meeting. I'll turn off YouTube and I'll turn off the recording. Okay. Thank you all. Have a good day.
Thank you.
All right. With that, Ms. Thompson, would you please begin the announcements?
Jessica Thompson, attorney for the department, ready.
Samantha Winky, family-based safety services worker.
Carol McKetta, family-based supervisor.
Kathleen Savage, attorney for the respondent mother, Carly Johnston. She's present when ready. Ms. Johnston, if you can unmute and announce your name for the record, please.
Carly Johnston.
And Olivero Flores for respondent father, Robert Spear, present and ready as well, Your Honor. Mr. Spear, can you say your name as well?
Robert Spear, ready.
Jennifer Harris, attorney ad litem for the child. And I apologize, Judge. I'm getting pulled over and I will turn my screen on.
Okay. All right. We were originally set back last Thursday. That day, Mr. Spear appeared with counsel and entered an appearance, and Ms. Johnston had been served, but we were reset to today so the parties could do some conferring. Ms. Thompson, where do we stand today?
Your Honor, I believe Ms. Johnston, she's agreeable to working services. As for Mr. Spear, I think for a large part he agrees to services with the exception of the BIP class.
Okay. Ms. Savage, is that your understanding?
Yes, Your Honor.
Mr. Flores?
Yes, Judge. There's another change in one situation where we're asking to have one of the courses be done at a different facility that my client has already started. But other than that, the BIP course and the random drug testing is the main concerns that we have that we like for the court to make a decision on.
Ms. Harris, is that your understanding?
It is, Judge.
All right. Let's start out by telling me what is agreed, and then we'll hear evidence on the BIP and the random drug testing.
Would you like for me to state that, Judge?
No, Ms. Thompson, if you just want to state what is agreed at this point in time.
As for Ms. Johnston, it is agreed to complete an intensive outpatient substance abuse program with lifetime recovery and follow all recommendations for aftercare, to complete random oral urinalysis and hair follicle drug and alcohol testing, to take part in domestic violence programming with optimal counseling via virtual and follow all recommendations, to participate in individual counseling with Ms. Patricia Boone, to follow all safety plans created in this case, as well as bond conditions, and to sign all releases to allow caseworker to speak to the providers. And as for Mr. Spear, to complete an intensive outpatient substance abuse program with lifetime recovery and follow all recommendations for aftercare, to participate in individual counseling in person with Joni Chavez and follow all recommendations, to take part in parenting classes with Fatherhood Campaign virtual, to complete a psychological assessment with Dr. Baldwin.
Slow down just a second. I want to make sure I'm getting all this. You want him to do intensive outpatient and then therapy with Joni Chavez Martel?
Correct.
Okay, what was the next one?
To participate in parenting classes with the Fatherhood Campaign, to complete a psychological assessment with Dr. Baldwin and follow all recommendations, to follow all safety plans created in this case, as well as bond conditions, and to sign all releases to allow caseworker to speak to the provider.
Okay. So the only two remaining items that are not agreed is that you want Mr. Spear to do batter's intervention and random drug testing.
Correct.
Okay.
And Judge, can I clarify two of those briefly?
Sure.
When it comes to, my client is okay with the intensive outpatient, but he's actually started treatment through Celebrate Recovery. So one of the questions we had also for the court was to allow Celebrate Recovery to be the intensive outpatient course. And then for the parenting course, the only other change to that was that in addition to the BIP course to be done instead of through the program that was mentioned to use Compadres and Compadres, which is a course that we've looked into. My client has already done some of the registration process for it, and that would include any kind of parenting courses moving forward. And so those are two separate other requests from it.
I need clarification. I understand the request for the Celebrate Recovery as opposed to intensive outpatient. So there's two parenting requests that the department has, BIP and then the fatherhood. Are you saying you want to do this other program instead of both of those, or the other program instead of BIP?
The other program instead of both of those. I think if you want to do a 1-for-1, it's probably closer to the other program, is more attuned to the parenting courses. But I think it would also have, arguably, when we get to that point, something that can help with the BIP portion as well.
Okay, so Mr. Spear's request is to do Celebrate all of the stated items, but to do Celebrate Recovery instead of intensive outpatient, and instead of batter's intervention and the fatherhood campaign to do Compadres y Compadres. Is that what you said?
Yes, Judge.
Okay. All right.
And Your Honor, just in regards to the mother's outpatient, it was agreed that she could switch to Hokata for her outpatient treatment.
Any problem with that, Ms. Thompson?
No, Your Honor.
So instead of Lifetime, we would do Hokata. Okay. I think I know everybody's position. Ms. Harris, is there anything I need to hear from you before we hear from Ms. Winky?
Mom has been very communicative, very open, really on the ball with everything. Hope to see Mr. Spear do the same thing. Blakely's doing well. It's great how she's in. She's got family support, everything she needs. I would advocate for there to be BIP and hair testing. Those are at the heart of this case and why we're here. So I think it's important to do those.
Okay. Ms. Winky, let me ask you a few questions. You heard everything that Ms. Thompson said as far as the services that were agreed. Do you believe those are in the best interest of the child?
I do.
All right. Now, Mr. Spear has made the request to do Celebrate Recovery instead of intensive outpatient. Do you have, and based on your knowledge of this case, do you have a feeling on whether or not that would be appropriate?
I do have a feeling about that. Yes, sir.
Okay, let me hear it.
So I have concerns. I think that Celebrate Recovery is a great program as an aftercare after he completes an intensive outpatient program and follows all those recommendations for inpatient. But I do not feel like Celebrate Recovery as a standalone program is appropriate to address why we're here and the seriousness of the concerns. So if he wants to do Celebrate Recovery in addition to his intensive outpatient through lifetime, I think that that's a great thing. But I think as a standalone, it's not enough.
Okay. And then what about the compadres program rather than the BIP and the fatherhood?
I think that I would have to look into the program. I think that it could probably be used in lieu of fatherhood campaign. That would be fine. But I don't feel like that's going to be enough to address the seriousness of why we're here. We're talking about a pretty serious incident of domestic violence in a moving vehicle with a gun present, with alcohol being consumed by both parties.
Mr. Spear, don't shake your head. No, your attorney will have the opportunity to cross-examine Miss Winky, but I don't want to see your reactions. Okay, go ahead, Miss Winky.
Sorry.
In addition, he's on probation for an incident of domestic violence that occurred in 2022. He's being asked in that program to complete BIP as well. So he needs to complete BIP either way. And if he does it with us, we'll pay for it. And it's going to help the CPS case. It's going to help him get the safety plan lifted and address why we're really here. This is a tool. It's not meant to punish. It's meant to help Robert and Carly both to have a healthy relationship. It's not fair right now that Carly's doing all the heavy lifting and doing what she's got to do. And she's only one piece of the puzzle. There's two parts here that need to fit together. And he needs the help too.
Okay. As far as the case as a whole is concerned, do you believe that there was abuse or neglect that occurred, or there's a substantial risk of abuse or neglect or continuing danger to the physical health or safety of the child, which would be caused by an act or failure to act with parents?
Absolutely, yes.
All right. Do you believe that the services that are stated here today are necessary to ensure the physical health or safety of the children?
I do.
So one child here. And you believe they're reasonable and necessary services?
I do.
Did you make attempts to work with the parents prior to the department filing the suit?
I did.
Okay. And were those attempts unsuccessful?
They were mostly successful with Carly, but with Robert, they were not successful, no.
Okay. Ms. Thompson, questions for Ms. Winky?
Ms. Winky, when was your first attempt to follow up with Mr. Spear to discuss his family plan of service?
I met with him on March 13th in order to present the family plan of service. I developed the family plan of service on January 31st, but all through February, he dodged me and I wasn't able to meet with him to go over that. But we finally did get to meet on the 13th of March.
And Ms. Winkie, have Mr. Spear submitted to a random drug testing previously?
He did on one occasion.
Do you recall what date?
Yes, it was November 15th, 2024.
And did you receive the result for that test?
I did.
And what was the result?
He was positive for methamphetamine on a urine test, and then he refused to do the hair follicle that was asked of him.
Are you also asking the court to, is he scheduled for an upcoming drug test?
Yes, I scheduled him for a test. I did.
Okay. And when is he scheduled to submit that test?
Tomorrow at 10:30. We're asking that he complete both a urine and hair follicle drug test.
And are you also asking for Mr. Spear to agree to twice monthly face-to-face meeting with you?
I am.
No further questions, Your Honor.
Ms. Savage, any questions for Ms. Winkie?
No, Your Honor, not this time.
Mr. Flores?
Yes, Judge. Yeah, just a few.
Go ahead.
Ms. Winkie, when you mentioned the attempts to contact Mr. Spear, did he mention to you that he was trying to get an attorney?
He did. He mentioned that when we met.
And so when you were saying that your attempts to contact him were unsuccessful, doesn't it just seem like he was trying to get an attorney and exercising his rights to have an attorney whenever he meets with you?
No, because he didn't tell me he was getting an attorney until March 13th. That was the first mention he made of an attorney. And all through February, I tried to reach him. I offered on February 10th. He said he was too busy. On February 18th, he actually agreed to meet me in my office, but then didn't show up. And there are times I've contacted him and said, I've got these 4 dates and times. Can you pick one and let me know? And none of those were successful.
Okay. But so he didn't tell you until the 13th of March, right?
He never mentioned an attorney until the 13th of March.
But isn't it possible that his whole time he was thinking about it, but just hadn't told you about that yet? Isn't that possible?
It's possible.
Okay. And so when it comes to looking at the drug testing that was done, you said it was a urine test, right?
Yes.
And that was back in November of 2024?
Yes.
Did you ask him if he was taking any medications when he had the drug test?
I did.
And did he tell you that he was prescribed Adderall?
He did.
And isn't it true that that can also present a positive urine drug test?
Not for methamphetamine, it can't.
Okay. We'll disagree on that part, but I understand. You said that he's currently under some pretrial services as well, correct?
Yes, I learned that yesterday.
And part of that is that he undergoes random drug testing. Is that correct?
Yes, I believe so.
And you're aware that he has no positive tests under that random drug testing that he does for any outstanding cases?
Objection, calls for speculation and hearsay.
Sustained. Please rephrase.
Are you aware of the results of those random drug tests?
No.
Okay.
And he also didn't start until Monday, so he's not been on probation until 2 days ago. So I'm not aware that he was drug tested prior to that.
Okay. So when you say that he started probation, what are you talking about?
In 2022, he choked Carly, and he subsequently has been put on probation. That was transferred to Bandera as of Monday, and he meets with Officer Xavier Torres.
And you're saying this is a probation case that he's under right now?
Yes.
How did you get this information? I can get with my client on this, but I don't think this is something that's going on right now. Where is this case out of?
The case is out of Uvalde, but he transferred the probation to Bandera, where he is currently living. He met on Monday at 9:30 with Xavier Torres, who's a probation officer, and was put on probation for the strangulation incident.
So if it was transferred on Monday, it would have been pre-existing then, right?
I mean, it happened in 2022, but when I spoke with Uvalde probation, they said that he's beginning probation in Bandera.
Okay. But you're saying he never had any probation in Uvalde before. It just started right now.
I don't believe so.
Okay. But you're not sure of that.
The way it was explained to me, he started on Monday.
Okay. And so you're sure of that, but you're not sure of any drug tests he would have had before then. Is that what you're saying?
I'm not. He's mentioned going to Harris County to drug test, but he never provided me with any results other than verbally saying that he was negative.
Okay. When it comes to Celebrate Recovery, versus Lifetime Recovery, right? That was the recommended one, correct?
Lifetime is recommended, yes.
Okay. What are you seeing as the differences between the two programs?
One's an intensive outpatient program with a certified LCDC, a drug treatment specialist, and one is not.
Okay. And you're not asking that Ms. Johnson take the same course, correct?
Ms. Johnson's also an intensive outpatient.
But that's being transferred, correct?
She's going to go to Hillcotta, yes.
Okay. And that's not an intensive outpatient?
Yes, it is an intensive outpatient.
Okay. Regarding the BIP course, are you aware of any affidavits that Ms. Johnson has filed in any cases with Mr. Spear?
I have heard that, yes.
And does she have an affidavit disputing the facts as they've been alleged against Mr. Spear from any incidents?
She mentioned to me that she did so in the 2022 incident.
Okay.
I wasn't sure what's going on with the Harris County. I know that she wants the charges dropped, but the state it looks like they're still picking up the charges.
And the next court date on that one is April 9th. Is that correct?
I wouldn't know because your client hasn't communicated that to me.
Okay. But you're under the impression that Ms. Johnson would like for them to be dropped moving forward, correct?
Yes.
Okay. And that she disputes the facts as alleged against Mr. Spear. Is that correct?
Yes.
Okay. I'll pass the witness, Judge.
Ms. Harris.
Have you been able to obtain, without telling me what it says, have you been able to obtain arrest records for Mr. Spear?
Partially. I have received the ones from the charges picked up in Gillespie County with the possession of methamphetamine. But the one in Harris County, it just takes a long time. It's a big county and working with them is a little bit more difficult, but the request is in to obtain those records, yes.
And based upon what you've been able to review, is drug treatment appropriate?
Absolutely.
based upon what you've been able to view, is domestic violence counseling appropriate?
Absolutely.
Whether you take Mr. Spears and Miss Johnston's explanations of what occurred in the incidents where police were involved, whether you believe their version of it or not, is domestic violence training appropriate for both of them?
Absolutely.
And why did Mr. Spear say that he tested positive for methamphetamine?
He stated it's because he's taking Adderall. He states it's prescribed to him. I don't know that for a fact. But it's because he's taking Adderall and because he took Vicks at the same time. And he thinks that when you take Vicks and Adderall at the same time, it results in being positive for methamphetamine.
Do you think that in and of itself warrants drug treatment?
Yes.
These parents love their child, right?
Yes.
And I think they can probably take good care of them if they address their issues, correct?
Yes.
And is that why you're asking them to complete all the services as requested, including BIP and intensive outpatient?
Yes.
And drug testing to include hair testing and nail testing if needed?
Yes.
I'll pass the witness, Judge. I'm sorry, one more question.
Go ahead.
It was a fairly severe incident that led to this case coming in, right?
Yes.
The child was in the car?
Yes.
And so, in your experience in the past, have those kinds of cases typically led to a removal of the child?
It has.
So is this kind of case the department's attempt to try and keep the child at home while getting the parents the help they need?
Absolutely it is.
No further questions, Judge.
Any rebuttal, Ms. Thompson, or redirect?
No, Your Honor.
Any other questions for Ms. Winky from anybody else?
No, Judge.
Any other witnesses?
No, Your Honor.
Anybody else have a witness to call?
Yes, Your Honor. I would like to call Mr. Spear.
All right. Just before we go out of turn, Ms. Savage, Mr. Flores, you don't have any witnesses to call?
No, Judge.
No, Your Honor.
All right. You may proceed, Ms. Harris. Mr. Spear, could you please unmute? And remember, you're under oath. You're under oath, and Ms. Harris is going to ask you some questions. The other attorneys are going to have the opportunity to ask you questions as well. Please only answer the question that you're asked. Don't offer any other information. And make sure that you give the attorney time to answer or ask their question before you answer it. Okay? Go ahead, Ms. Harris.
Mr. Spear, when was the last time that you used methamphetamines?
It's a while back. I'm not sure on the date.
Approximately.
Months.
Okay, so sometime in 2025?
Yes, ma'am.
I'm going to object to answer, Judge.
Overruled.
And when you were arrested and the methamphetamine bag was found on your person, who did that methamphetamine belong to?
I'm going to object and advise my client, Your Honor, that if any questions coming forward are regarding any kind of criminal charges that are still pending, that he exercises right to the Fifth Amendment.
Mr. Spear, your attorney has raised an objection. I want to make sure you're aware of the fact that pursuant to the Fifth Amendment of the United States Constitution, you have the right to not incriminate yourself. So if you're asked a question that would require you to answer in a way that could subject you to criminal liability, you do not have to answer it, but I will need you to state that you plead the Fifth Amendment. I need you to understand that when you're in a civil proceeding, such as what we're in now, if you plead the Fifth Amendment, I, as a civil judge, can infer whatever meaning from that I want to take. But you do not have the obligation to incriminate yourself. You are protected from that. Do you understand?
Yes, sir. I think so. Yes, sir.
What do you not understand? I want to make sure this is very clear.
Just so I can Yes, sir. I believe I believe I do.
Okay. If you're in doubt, plead the fifth.
Yes, sir.
I
Okay.
just need you to understand that I can infer whatever I need to infer from that.
Yes, sir. I understand.
All right. Go ahead, Ms. Harris.
Who did the methamphetamine in the bag belong to, sir?
I invoke my Fifth Amendment right.
Okay. And has there ever been any domestic violence between you and Miss Johnston?
I'm going to advise my client again, Your Honor, about his ability to plead the fifth.
Yes, I'm going to go ahead and plead my Fifth Amendment right.
I'll pass the witness, Judge.
Ms. Thompson, questions for Mr. Spear?
No questions, Your Honor.
Ms. Savage?
No questions, Your Honor.
Mr. Flores?
Judge.
Okay. Any other witnesses, Ms. Harris?
No, Your Honor.
All right. Does everybody rest?
Yes, Judge.
Yes, Your Honor.
Yes, Judge.
Yes.
Okay. I'll give everybody an opportunity to make an argument. Ms. Thompson?
Your Honor, as you heard through testimony, it's in the best interest to grant the department's motion pursuant to the Texas Family Code 264-203, Section M. As you've seen her testimony through Ms. Winky, that there is a substantial risk of abuse or neglect of the child in this case, and that services are necessary to ensure the physical safety and health of Blakely. I mean, given the extensive history of domestic violence involving the respondent parents, it's really necessary and vital to order the services needed to address those needs.
Thank you, Ms. Thompson. Ms. Savage?
Your Honor, I would ask the court to accept the agreements that the mother, Ms. Johnston, entered into with the department regarding her services, to include the intensive outpatient with Hokata, the random drug testing, the domestic violence, the counseling, and following all safety plans. She has already begun in these services, and so hopefully this will be a case she's able to complete quickly. Just for the court's knowledge, Compadre is a parenting program for men in San Antonio used frequently in the Bexar County cases. It is a 15-week in-person program in San Antonio. So it is a great parenting program. Just wanted to provide that information to the court.
Do you believe, Ms. Savage, based on your understanding of that program and your experience with it, are you representing to the court that it would be the same intensity as BIP?
Compadre is just the parenting class, Your Honor. It is not a BIP program. But
Right.
if Mr. Spear were to choose to do the Compadre over the requested parenting with fatherhood campaign, I think it would be on par with that program. But it is not a BIP program.
Right.
Full transparency to the court.
Yeah, and that's my understanding is that's what the father was requesting, was to replace both of those with BIP. But you're telling me that Bexar County uses it as basically a parenting program, but not as a replacement for a BIP class.
Correct.
Okay, thank you. Mr. Flores?
Judge, I just want to present to the court the fact that we do have cooperation and agreements from my client regarding several of the requests by the department, and we would like for you to follow the agreements that we have regarding the following all recommendations of the safety plan regarding the releases, regarding having a parenting course be completed. And we'd still prefer, Your Honor, moving forward, and individual counseling, sorry, Your Honor, that was part of the agreement as well. But we would still be requesting from Your Honor that we be allowed to conduct our Celebrate Recovery. My client has already registered with them. He did his first meeting with them this past Monday on the 31st of March. I think any concerns can be completed there and can be solved for my client by attending and continuing to attend Celebrate Recovery. Obviously, we have a disagreement between whether or not we think that Adderall can cause a positive test for methamphetamines moving forward. But that's just a disagreement we'll have without an expert here, Judge. There's not going to be somebody to break that tie between at least the parties before the court. The court always gets to break that tie. Moving forward, Judge, I think that none of the concerns really, aside from some testimony about an incident that occurred in a vehicle, which from the additional testimony of it is disputed by both parties as to what exactly happened, really shows that there are any issues with my client and his ability to take care of Blakely or provide care for Blakely. I don't believe there's any orders in the court. I think that previously there was a mention that there was some kind of order preventing him from seeing Blakely, and that's not the case. Any pretrial services or orders just stated that any type of visits would have to be conducted where a third party does the exchanges, but other than that, there were no restrictions on him. And so moving forward, we show the court that there were no concerns brought up today really of his care of Blakely or his ability to care for Blakely or any danger that he really presents to Blakely. Again, Judge, I think I understand their request for BIP, but I think that a parenting course that's a 15-week intensive program would put my client on the right path. It would show him the strategies and skills he needs moving forward. And I don't believe, since both parties disagree with the way that the events have been stated and charged and moving forward with, given those facts that everybody disagrees with, I don't think it's necessary moving forward in this case, when the only people that were there are telling this court through testimony of other parties that that's not what happened and that those accusations are false. And so moving forward, Judge, I don't see the need to have those, and we'd be requesting that from the court.
Ms. Harris?
Your Honor, I think the fact that the department is pursuing this kind of case as opposed to removal is a huge step on their part to try and keep the child in the home. And Ms. Johnston jumped on everything. She's been doing things for several months. So keeping the child in the home with her, I think it is a great step on the part of the department. It's Mr. Spear that has refused to do anything. I think that the arrest, the affidavit, what you can infer from his answers indicate that there is very much a need for BIP. There is very much a need for drug treatment. There is very much a need for parenting. And I don't think it's fair to say that it's one incident. It has been more than one incident. And I think the testimony shows that the child was in danger. The testimony was that the child was in the vehicle when the most recent incident occurred, when the methamphetamines was found on Mr. Spear. So normally this would be a removal case, and I think that they might be able to make that case if they were forced to. So what the department is asking Mr. Spear to do, I think, is a pretty darn good deal and a way to be able to keep this child at home. So I'm asking that he be ordered to do everything that's been requested.
Thank you, Ms. Harris.
And I'm sorry, and Your Honor, for visitation, the same thing, I would ask that it be supervised. I think visitation should occur. I also looked at his bond requirements, and I think that it anticipated contact with his child. It's just the exchange has to happen with somebody besides Miss Johnston based on his other bond conditions. So because there are bond conditions in place, because there is a case pending, I would ask that the visits be occurring weekly, supervised by the department.
Thank you. All right, I'll approve the provisions of the agreement that the parties were not contesting. And I'm going to make the findings that Ms. Winkie testified to, that there's sufficient evidence to satisfy a person of ordinary prudence and caution that abuse or neglect has occurred, or there is a substantial risk of abuse or neglect or continuing danger to the physical health or safety of the child caused by an act or failure to act of the parents. services are necessary to ensure the physical health or safety of the child, and the services are to be narrowly tailored to address the findings that the court is making. I'm finding that, you know, this stuff has occurred and we've got some issues we need to address. Mom is going to do, these are the court's orders. Mom is ordered to participate in intensive outpatient with Hikato, to submit to random oral UA and drug and alcohol testing, to do domestic violence programming with optimal counseling virtually and follow all recommendations, to adhere to the safety plan, to participate in individual counseling with Patricia Boone, to sign the releases to allow the caseworker to speak to the providers. Mr. Spear is doing what's agreed as intensive outpatient, is in doing the therapy with Joni Chavez Martel, parenting, psychological assessment with Dr. Baldwin, and follow the recommendations, follow the safety plan and his bond conditions, and to sign releases. I'm going to order the weekly visitation to be supervised, provided it does not conflict with the bond requirements that he has. Now, regarding father's requests to change up some of these services, I am familiar with Celebrate Recovery. To take judicial notice that I understand what Celebrate Recovery is. I understand how it works. They used to do it at a church I attended, and I saw them do this process. I think, as Miss Winky testified, Celebrate Recovery could be a wonderful supplement to what Mr. Spears needs to do, but these allegations are troubling. The allegations are pretty severe, and it's not just one, it's not just two. There's three different things we have going on here over the course of time that concern me. And Miss Harris is right. If we were looking at this case 2 or 3 years ago, you know, we're looking at a removal, but the law has changed, the legislature has changed. Things have gotten to where we want to try to do these cases within the home and allow the children to stay in the home. And I'm just concerned about not nipping this in the bud where we can. Mr. Spear, I'm going to be honest with you and frank with you. I'm concerned about your reactions to some of the testimony that you heard. I'm concerned about your attorney has done a fantastic job of arguing on your behalf. But, you know, I've got evidence in front of me that I can't ignore. I can't order things that aren't going to get us to the meat of this issue. If your family is going to be, first of all, if we're going to avoid a removal in this case, which is what everybody's trying to do, then we've got to have services that are going to help us to do that. Because I can't tell you how many times I've been involved in these cases where we don't get severe enough at the outset. We don't remove a child. We don't address the issues. The children go home. I either have to close the case because the parents refuse to cooperate, or I close the case because we all think everything is addressed. And then I get the case back as a removal. And then we're in this family's life for a year to 2 years. I would much rather get all this stuff done and be intense with it, get to the issue, and not be in your life for a year or two.
Yes.
Ms. Johnson, I'm a little bit concerned. It's your prerogative, but I'm also always going to be a little concerned when I have a parent in a domestic violence case who is making it known to everybody who's supposedly the victim that they want to make the charges go away. And it's not the first instance of domestic violence. In my opinion, based on the evidence I've heard, you two are exactly the type of people that need to be in batterers intervention prevention courses and domestic violence courses. They're designed for people like you so that we don't have this continuing thing happening generation after generation to where we accept this type of behavior. I'm glad that your child is at home with you. I'm glad that you've jumped into services, but I want to make sure that you both have the education that you need to understand how serious this could be. This incident in the car could have gone a very, very different way. Somebody might not be here with us right now. that happens all the time. I don't want to see that happen to you. I think that, as Ms. Harris said, you're very, very, very fortunate that we're in this case on a court-ordered services case, and we're not dealing with something much more severe, and we're not dealing with a case that's gone to the level where your child has been removed from you. So I'm glad that you're willing to start off on the right foot and agree to some things, but I'm going to order that both of you do the BIP, and I'm going to order that you both are involved with, well, let me take that back. Mom is going to do what she agreed to do. Mr. Spear, I'm going to order that you do the BIP course. You can do the compadres and compadres versus the fatherhood course. That's fine, but you've got to do the batterers intervention course. That has to happen. And I'm also going to order that you submit to the drug testing. Look, you pled the fifth. That's fine. I've got a case where there's concerns of methamphetamine use and there's domestic violence. In my experience on the bench and my experience as an attorney in these cases for a long time, those two things often go hand in hand. So I'm not going to take any chances, and I'm going to make sure that we address these concerns, whether they are, you agree with them or not. So I'm going to order that you do the drug testing as well. If you don't go drug test, if you refuse or you miss one, there's only one thing I can assume from that. There's only one thing I can infer from that. I know that there's been some allegations of methamphetamine, and I'm making these orders. So if you pop positive on a drug test before this court, I'm not going to dock you for that. I'm already making the orders. So, but if you miss one, then I've got to infer that you've got something to hide. But if I know that you're taking them and the levels are going down, then I know that you're making progress. That's what I need to see. So the agreements are ordered, and the orders include father doing the drug testing, the batterers intervention course, and he can do the compadres if that's better. I'm also going to order that he meet face-to-face with Miss Winky twice a month. Don't miss those meetings. And again, if the bond requirements don't prohibit the visitation, then I want that to happen weekly. I want you to see your daughter. I want you to develop a really good relationship with your daughter. And as you go through these classes, I want you to learn things from them that help you be the best parent you can be. Our next hearing is going to be a progress hearing, June 26, 2025 at 10:30. June 26, 2025 at 10:30. At that hearing, that's over 2 months from now. I don't want to come back to that hearing and find out we haven't made progress. I don't want to find out at that hearing that there's a lot of arguments and there's a lot of fighting over these orders. These are orders of the court. There's only one thing you can do, and that's comply with them. You can refuse to comply with them, and you can try to get around them, but that's not going to help you in this case. I've seen it before. It's not going to be a surprise to me. You're not going to fool me. I want to see you guys get through this case, and I want to see progress made, and then I want to see us come to the day where I could say it's dismissed. Good job. I'm proud of you both. Don't ever come back. That's what I want to see. All right. Miss Thompson, is there anything I failed to address?
Yeah, not failed to address, Your Honor, but the department also asks the court to order Mr. Spear for his drug test tomorrow, April 3rd at 10:30 at G&G Consulting, to not alter his hair in any way or in any manner,
So ordered.
as well as to release his physical and mailing address to the department.
So ordered. We can't get this case done if we can't find you. All right. Anything else? All right. Good
No, Your
luck to
Honor.
both you parents. If you have any questions, you can contact your attorney, but you can also contact your caseworker. You can also contact the attorney ad litem. These are resources for you. These are people that can help you get this stuff done. So there shouldn't be any reason to not be able to find stuff out. You have several resources. All right. I'll see you June 26th at 10:30. Good luck. Thank you all for your time and your service. All parties are excused.
Judge, on June 26th, is that on Zoom or in person?
At this point in time, it's on Zoom. Unless something changes, we'll let you know.
Leslie Levy, attorney
Thank
for
you.
the department. State is ready.
Richard Saldivar for the mother. Ready, Judge?
Anna Swallow, attorney, guardian ad litem for the children, ready.
Dee Sevilla, caseworker for the department.
Ms. Salinas, would you please unmute and announce?
Marisa Salinas, mother.
All right, if there's someone else in the room with you with a device on, they're going to need to mute it. Otherwise, we're going to get an echo and it's going to be hard to hear everybody. Okay, anyone who's not an attorney or will be giving testimony, please raise your right hand. That includes you, Ms. Salinas. And who's the ma'am? Can you state your name on the Samsung? You have to unmute.
Dusty Moultrie, TFF therapist for Miss Salinas.
Okay, thank you, Ms. Moultrie. I see you, but I've got somebody else here on a Samsung phone. Ma'am, can you state your name?
Yes, Alicia Hernandez. I'm Marisa's mother.
Thank you. All right, hands up if you're testifying or giving testimony. Do each of you swear or affirm the testimony that you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Yes, Your Honor.
Yes, Your
Honor. Yes.
All right, and Ms. Levy, you all have an agreement?
Yes, Your Honor, the department's in agreement to non-suit this case. It's my understanding from talking to the parties that there is a TFF case separate and apart from this. It sounds like the attorney ad litem would like to see some individual therapy, and there are 6 months for the mother to provide proof of engaging in the case voluntarily that would negate the need for legal intervention. So at this time, the agreement of the parties is to non-suit this traditional MTP and just have the TFF case run its course.
I was going to say these faces and names seem familiar to me. Which county is that out of? The other case?
Uvalde.
Okay, so how did we get to?
Judge, the first one was a TFF case, and so there were some issues that the department believed that we needed to convert this to a motion to participate. And so we've discussed those issues, Judge, and we're going to just keep it as originally filed.
I remember that now. Okay, sorry, there's a lot of cases to keep straight. I do recall hearing something about that or reading something about that. Okay, all right, so the agreement is to non-suit the TFF and let the court-ordered services case run its course? Or other way around?
Other way around, Judge, yeah.
Yeah, non-suit the court-ordered services case and let the TFF case run its course. Okay. Do I need to hear anything else, or is that it? Okay, well then if there's no objections, I'll grant the motion to dismiss the court-ordered services case, and we'll just continue on in the TFF case. There'll be no further hearings. Thank you all. All parties are excused, and that concludes our docket for today. Have a good afternoon.
Thank you, Judge.
Wait, Judge, it's me.
Yes.
Okay, so this case I am non-suiting,
Correct.
keeping the other one open. Okay.
Correct.
Good. Okay.
Got it?
I got